A parenting order in Australia is an order made by a court under the Family Law Act 1975 about parenting arrangements for a child. Parenting orders can cover a wide range of issues, such as who the child lives with, spends time with, communicates with, and other aspects of parental responsibility. Here are some hypothetical examples of what a parenting order might include. Residence order. This is an order specifying whom a child will live with. For instance, a parenting order might stipulate that a child will live with parent A from Monday to Friday and with parent B every weekend. Contact order. This is an order specifying when and how a child will have contact with a parent with whom they do not reside. For example, a parenting order might specify that a child will have video calls with parent B every Wednesday evening and spend every other weekend with them. Shared parental responsibility order. This is an order that parents must consult with each other about major long-term issues affecting the child, such as education, religion, and medical treatment. For instance, a parenting order might stipulate that parent A and parent B must jointly decide on the child's school or any significant medical treatment. Specific issue order. This is an order dealing with any aspect of parental responsibility or with whom the child communicates. For example, a parenting order might specify that the child will spend Christmas Eve with parent A and Christmas Day with parent B, or that parent A is responsible for taking the child to any medical appointments. Non-removal order. This is an order preventing a parent from relocating the child without the court's or the other parent's consent. For instance, a parenting order might stipulate that parent A cannot move the child out of the state without the court's permission or the agreement of parent B. In the Australian family law context, a residency order is a type of parenting order that decides who a child will live with. This type of order can also specify when and how a child will spend time or communicate with a parent they don't live with. Here are a few hypothetical examples to illustrate different forms a residency order might take. Sole residency order. This order might stipulate that the child resides solely with parent A due to, for instance, a history of abuse or neglect by parent B. Parent B might be given specific times to communicate with the child through phone or video calls, under supervision if deemed necessary. Joint residency order. This order may declare that the child lives with parent A for 1 week and then parent B for the next week, rotating on a weekly basis. This can be appropriate where parents live in close proximity to each other and the child's school to minimize disruption to the child's routine. Primary residency with visitation. An order might state that the child primarily lives with parent A, but spends every other weekend and half of school holidays with parent B. This arrangement is common when one parent has been the primary caregiver and it is considered in the child's best interest to maintain that situation. Split residency order. In cases involving multiple children, an order could specify that child 1 lives with parent A and child 2 lives with parent B. This is less common, as courts usually prefer to keep siblings together, but may be deemed appropriate in certain circumstances, such as when the children have a significant age gap or differing needs. A contact order, sometimes known as a spend time with order in the Australian legal context, is a type of parenting order that specifies how a child will spend time and communicate with the parent they do not live with. Here are some hypothetical examples of contact orders. Weekend contact order. The contact order might specify that the child will spend every other weekend from Friday evening to Sunday evening with parent B. This is a common arrangement, especially when parents live relatively close to each other. Holiday contact order. The contact order might stipulate that the child will spend half of the school holidays with parent B. This can be an appropriate arrangement when the parents live far apart, making regular weekend visits impractical. Special occasions contact order. The order could specify that the child spends alternate birthdays, Christmas days, or other special occasions with parent B. This type of order can help ensure that both parents have an opportunity to share significant events in the child's life. Supervised contact order. If there are concerns about the child's safety or well-being while with parent B, the order might specify that visits must be supervised by a mutually agreed upon third party, or through a child contact service. Indirect contact order. In some cases, it might be ordered that the child will communicate with parent B through letters, phone calls, or video calls. This type of order may be appropriate if parent B lives overseas, or if there are concerns about direct contact. Graduated contact order. If parent B has been absent from the child's life for a long period, the court might order a gradual increase in contact over time. This could start with short, supervised visits, progressing to longer, unsupervised visits as the parent and child re-establish their relationship. In the Australian family law system, a parental responsibility order is a type of parenting order that relates to the powers, duties, responsibilities, and authority which, by law, all parents have in relation to their children. This order can detail who has responsibility for daily decisions and long-term decisions. Here are some hypothetical examples. Equal shared parental responsibility. An order could stipulate that both parents will share equal parental responsibility. This means they are required to consult each other on long-term decisions, such as those about the child's education, religious upbringing, health care, and cultural matters. Sole parental responsibility. An order might provide that one parent, say parent A, has sole parental responsibility for all decisions concerning the child. This might occur in situations where parent B has a history of family violence or neglect, or is otherwise unable or unfit to participate in decision-making. Divided parental responsibility. In some cases, the court might order that certain aspects of parental responsibility are held solely by one parent and other aspects are held solely by the other. For example, parent A might be given responsibility for decisions about the child's education, while parent B is given responsibility for decisions about the child's health care. Sole parental responsibility with limited consultation. The court might order that parent A has sole parental responsibility but must consult with parent B about major decisions. For instance, parent A must inform and consult parent B before making significant decisions, such as changing the child's school, but parent A has the final say. A specific issues order is a type of parenting order under Australian law that deals with any aspect of parental responsibility that falls outside of the typical residency or contact orders. Here are some hypothetical examples. Education order. This order might stipulate that the child must attend a specific school, or that the child must be homeschooled. For example, if parents can't agree on which school the child should attend, the court might have to make a decision based on what it deems to be in the child's best interests. Medical treatment order. This order could specify that the child is to receive a certain type of medical treatment. This could come into play if one parent objects to a particular form of medical treatment, such as vaccinations, and the court determines that it is in the child's best interest to receive that treatment. Religion order. An order could specify that the child is to be raised in a particular religious faith, or that the child should not be subjected to a particular religious practice. This might occur in situations where the parents have differing religious beliefs and cannot agree on the child's religious upbringing. Name change order. This order could stipulate that the child's surname is to be changed or not changed. For instance, if a parent wants to change the child's surname after divorce or remarriage, and the other parent objects, the court might need to decide on the matter. Travel order. The court could specify that a parent must not take the child out of a particular area, like the state or country, without the written agreement of the other parent or further court order. This might be necessary in situations where there's a risk that one parent might try to relocate with the child without the other parent's consent. A non-removal order is a type of parenting order under Australian law that restricts a parent from relocating a child without the court's or the other parent's consent. These orders are often used when there is a risk that one parent may attempt to move the child a significant distance away, potentially disrupting the child's relationship with the other parent. Here are some hypothetical examples. Domestic non-removal order. An order might state that parent A must not remove the child from the state of New South Wales without the written agreement of parent B or further order of the court. This could be used if parent B is worried that parent A may attempt to move the child to another state, disrupting the child's life and making it difficult for parent B to maintain a relationship with the child. International non-removal order. An order could stipulate that parent A must not remove the child from Australia without the written agreement of parent B or further order of the court. This might be used in situations where there is a risk of international child abduction. Specific area non-removal order. In some cases, the non-removal order might be even more specific, stating, for example, that parent A must not remove the child from the City of Sydney without the written agreement of parent B or further order of the court.